Law of trust. In the law of trust, firstly we must study the topic of equity. Equity is the base for the law of trust. The most significant equitable doctrine is the trust. The law of trust was born out of the equity's focus on acting on consents. Before we go into the subject matter, we must see or we must consider the pattern of the exam paper. This is the pattern of the exam paper. The exam paper of the law of trust, as other subjects in the law college, consists of 9 questions. The candidates are required to answer 6 questions. As you know, the first question is a mandatory or compulsory question which carries 20 marks. Every other question carries 16 marks. The first question may be in any of the topics that we have covered in the law of trust and equity. Now we will move to the recommended books. There are certain books recommended for reading. For Sri Lankan laws, the reception in Ceylon of English Trust by L.J.M. Hure is recommended for reading. For the English law and English system, legal system in relation to the law of trust, I strongly recommend Equity and Trust by Michael Hellion Lara, and another book I would like to recommend, Equity and Trust by Alastair Hudson. For this is all 2 books highly recommended for English law. In addition to that, students encouraged to read other books also. Now we will go into the subject matter. What is equity? Equity means that which is fair and just, moral and ethical. But its legal meaning is very much narrower. It is not synonymous with the justice in broad sense. Early development of equity categorized it as a separate system from then existing common law. The term equity is associated with the notions of fairness, morality, and justice. It is an ethical jurisdiction. When you say equity, it has some connection with fairness, morality, justice, and ethical values. Equity is the branch of the law that was administered in the Court of Chancery. This was the jurisdiction evolved to achieve the justice and to overcome the rigors and deficiencies of the common law. Equity cannot be equated to justice, but the equitable principles may be applied to find the justice in a given dispute or problem. Equity is not a part of the law, but it is a branch of the law, but a moral virtue which qualifies, moderates, and reforms the rigor and hardness and edge of the law. Equity assists the law where it is defective or weak. When we see the history of the English legal system, when you see the history of the English legal system, there was a well-developed common law and common law courts. Both together we can say English legal system. Then one side, common law and common law courts. The courts exercise the jurisdiction in accordance with the provisions of common law. After some time, the person who is grieved by the decision of the common law courts went to the king to get some sort of relief. King started hearing the matters and gave the relief to the people who were aggrieved parties of the common law courts. That is the way the equity system or the equity developed there. After some time, the king was unable to deal with the matter. Then the king appointed chancellor to manage these appeals. Then the chancellor is the legal or the judge there. On the other side, the administrative body is known as Court of Chancery. Then the Court of Chancery, headed by Chancellor, and heard the matters, whatever people complain to them, and giving the relief in accordance with their conscience. Then if there's a defect in the common law, the common law courts, they delivered the judgment in accordance with the common law. It may be injustice. That's why the Court of Equity started hearing the matter again and gave some sort of reasonable relief to the parties. Because of this procedure, equity qualifies or moderates or reforms the rigor or the hardness or the edge of the law. And equity assists the law where it is defective or weak. When we see here further, the common law and the common law courts are well-established system when the equity interferes therewith. What I mean here, equity interferes in the sense equity never interferes with the decision given by court or in delivering the judgment in court, in the common law courts. Aggrieved party made a complaint to the or made an application to the Court of Equity. Then equity has given the judgment or the order which was reasonable. That's why Court of Equity interferes therewith. The common law and common law courts, even though well established there at that time, then only equity interferes. Equity developed and gradually emerged as a distinct body of law. In times, the system became as a high bound by rules and principles as its common law counterparts. Now, after some time, there is a long history, about more than 600, 700 years, centuries and centuries history. First of all, when they started, the king started, and thereafter chancellor appointed by king, and the chancellery court was hearing the matter. At that time, there was no issue, there is no control at all. The chancellor has the full power to give the justice or relief to the parties in accordance with the consensus. But after some time, even the Court of Equity or Court of Chancelleries, the judgment and everything started reported. Once reported, then again, even the Chancellery Court little bit tied. That's why here, in times the system became as hidebound by rules and principles as its common law counterpart. Because common law is very clear, the judgment and everything is there, and the court system is there. Then the court system gave the judgment time to time. Every common law court system or judgment registered and reported. Therefore, after some time, even the Court of Chancellery can't go beyond the reported cases or beyond their judgment that they have given earlier. That's why here we say that in time the system became as hidebound by rules and principle as its counterpart common law. Then here we will see in this slide here, equity is the means by which a system of law balances out the need to achieve the fair results in individual circumstances. Now, one side, common law courts, common law judgment, all these things are there. Other side, court of equity giving powers and giving the judgment and relief and everything in accordance with the consent. This here, the common law courts giving the judgment in accordance with the common law. Then both sides, there are two separate systems at that time. Then what happened? Here there's a need to balance this out. That's why here need to balance. What balance here? One side common law very rigid and other side equitable principles. To achieve the justice, fair results in individual circumstances, common law courts, they will go in accordance with the common law. The equity courts, they will go in accordance with the consents. Then both put together, and really speaking, the Court of Chancellery balancing out the need to achieve the justice. Then equity mitigates the rigor of the common law, so that the letters of the law is not applied in such a strict way that may cause injustice. This is a clear idea here. If you apply the letters of the law, it may cause injustice. Equity assists to achieve the fair results. Every party to the dispute should satisfy that the justice is done. I don't say every party, in other way I can say the reasonable party must accept that the justice is done there. The relief ordered by court must be acceptable by all the parties. Again, I would like to say, again, by all reasonable parties. The letters of the law is not applied in such a strict way that it may cause injustice. For example, we will take some example here in Sri Lanka for the purpose of understanding the matter here. If there is a violation or infringement of fundamental right of a person, such person shall invoke the jurisdiction of the Supreme Court within the 1 month as specified in Article 126 of the Constitution. Technically, when you define 1 month, such person shall invoke the jurisdiction within the number of days of the month in which the violation or infringement occurred. If the violation occurs in the month of February, the person whose right is violated shall invoke the jurisdiction of the Supreme Court within 28 or 29 days, as the case may be, not within 30 days. Because 1 month, in the sense, we must clearly identify that the month in which the violation occurs. This is a good example to the reflection of common law. Common law always very rigid and strict. Now, if there is a violation, suppose there is a violation of fundamental rights or language rights, the person whose rights violated, hospitalized for some time, he or she couldn't file an action in the Supreme Court. In that case, if he files an action later, if you apply the provisions of written law, the court must dismiss the case, because the person whose rights is violated invoked the jurisdiction not in the time frame specified in the law. That is the reflection of, that's why here, that is the reflection of common law. Law is very strict. As you know, there are certain exceptions given to this rule of 1 month. Those are reflections of equity. Or in other case, the person whose rights violated may make an application to the Human Rights Commission of Sri Lanka. This is also reflection of equity within the reasonable time. When you go to the Supreme Court, when you read the Constitution, Article 126, you must make an application within 1 month time. But here in the National Human Rights Commission, you must make an application within the reasonable time. That is the reflection of equity. The modern equity appears to be substantive and procedural principles. The court exercises the discretionary powers to achieve the fair results. Nowadays, the discretionary powers given to the judges, you can't apply the provisions of law for each and every case. Therefore, it must be decided case by case, and the court must exercise the discretionary powers and give the fair results or give the justice to the people. That's why here we say that courts exercise the discretionary powers to achieve the fair results. Therefore, even the example that we have discussed here, what we should do is we must make as much as possible, we must study and we must see that whether we must go with the provisions of the law or we must go with the equity principles. There are circumstances we must go with the provisions of the law. There are circumstances where we must not go with the provisions of the law. We must apply our discretionary powers to achieve the justice there. Equity appears to imbue the courts with the general discretion to disapply statutory or common law rules whenever good conscience requires it. If there's a good conscience requires, then we should not apply the statutory or common law rules. Then we must deviate from the common law rules for the purpose of achieving the justice. But we should not do always. This can't be a power given to the judges or the court to go out of your written law. No, that should not be done. There are cases where we must go, where we must give some sort of justice to the parties. Then, of course, we must go or we must not apply the statutory provisions or statutory rules. Now, equity can be understood as the means by which English law ensures that strict application of common law or statutory rules does not result in any unfairness. To this extent, the equity is form of natural justice. It has moral basis. That's why when we say what's the meaning of equity, we have seen that it has some moral values. It is not justice, but it can be used. The equity principle or equitable principle can be applied to achieve the fair results. Therefore, here we say that equity can be understood. The means, as the mean by which English law ensure the application of common law does not result. Then always we must say, before the court apply the provisions of the law, must see that whether it leads to the fair results. It leads to the justice. If it leads to the injustice or it causes injustice, then that should be stopped. Then the court should not apply the common law or statutory rules. That is equity. We must apply the natural justice. What is simply we can say the natural justice. Before we punish somebody, we must hear his side. That is a basic natural justice. That is also one of the equitable principles. Equity can be considered in its formal sense as constituting the collection of substantive principles to judge the people's conscience. Then equitable principle, what is equitable principle? That is something, simply we can say this is a tool to judge the people's consciences. There are different ways of understanding the equity's role as part of English legal system. Equity's role, particularly the moral purpose, was described by Lord Ellesmere in the Earl of Oxford's case as being to correct men's consciences for frauds, breach of trust, and soften and mollify the extremity of the law. To soften and mollify the extremity of law, then what we should do, we must apply the equity. We must apply the consensus. That's very important. To correct the men, sometimes it may be mala fide intention or sometimes it may be bona fide intention. We must identify the mala fide consensus as well as bona fide consensus. If the person who has committed something, offense or act or wrongful act or whatever, with the bad conscience, then he is responsible for the act. A person does something without or with the good conscience, then he can't be responsible for that. First of all, as a court of chancery must identify the conscience of the person who has committed the act. Another way of understanding equity's role as people conscience. Equity can be considered in its formal sense as contributing the collection of substantive principles developed over the centuries by the courts of chancery. Principally, the court of chancery to judge people conscience. Then over the centuries, equity can be considered in formal sense, contributing the collection of substantive principles. Specifically, the court of equity in the sense, court of chancery, to judge the people conscience. That is the intention of the people. When a person who does something, then we must see the intention. That's the way we have studied in criminal law also. If a person commits an offense or commits an act, first of all, we must see the intention of the person who has committed such act. Like here also, in the law of trust or in the equity part, we can simply say the chancellery court, the ultimate aim of the chancellery court to judge the people conscience. Then we will move to other slide here. Equity should be understood as being a code of technical, substantive rules, not simply as a reservoir of general principles. The principles of justice and conscience are the basis of equity jurisdiction, but it must not be thought that the contrast between law and equity is one between the system of strict rules and one broad discretion. It has formulated for a long period of time. That's very important. The equity evolved, the equitable principles evolved for over a period of over the centuries. That means, as we have seen here, the first court of chancery is something in 13th century. Then up to 17th century, the bishops were chancellor. Then when you see this period, about 500 years, all these things considered on the basis of religious consensus as well as legal consensus, people consensus, defendant consensus. From all these consensus evolved the principles of equity. In this sense, equity may be understood as a code of technical substantive rules, not simply a reservoir of general principles. Finally, equity can be understood as comprising the procedural rules and forms of actions developed by Court of Chancery over the centuries under authority of Lord Chancellor. Over the years, more than 500 years, more than 700 years, the system of the equitable principles developed. The actions or forms of actions developed under authority of Lord Chancellor. In all legal systems, generally speaking, the statutory rules are created to deal with the general issues. Sometimes it causes injustice in certain individual circumstances because it is enacted or it is created for general circumstances, general issues. Now say suppose here in Sri Lanka, law is enacted by parliament. Law is enacted for general issues. But when you go into the matters of individual cases, then you have to modify, you have to apply the discretionary power and come to the final conclusion, which would be justice. Suppose that if you say that the court should deliver the judgment in accordance with the written law without saying any other discretionary powers or equity or equitable remedies or whatever, then we don't need to have a court system at all. Simply we can enter all the laws in the computer and just to enter the problem, then the computer will come up with a solution. Can we do that? No. Why? Definitely, in certain circumstances or most of the circumstances, it may be injustice. That's why the present days, the court or the judges given the discretionary powers. They can move, they can deviate in a way to give the justice or do justice. Always you can't strict with the laws. Sometimes it causes injustice. That we have seen in the fundamental rights violation also. If you say that the person should come within the 1 month time, if the person fails, then the case should be dismissed because you failed. Sometimes it may be a reasonable delay. Sometimes there may be some other reasons for the delay. Then you must consider those delay and make some reasonable adjustment or reasonable deviation from such laws. That's why here it is said that in all the legal system, the statutory rules are created to deal with the general issues. It causes injustice in certain individual circumstances. then what you should do is you must apply the equitable principles to find the justice or fair results. In this context, the English legal system, it is an equity which performs the balancing act when set against the rigidity of the common law. Balancing act, because common law courts never go out of the common laws. Common law courts are very rigid and very strong in the common law. They won't go out. Then sometimes they won't be able to find the justice. That's why the equity is there. Equity performs the balancing act. Balancing act in the sense, one side common law that's very rigid, other side equitable principles. The ultimate purpose of the equitable principle is to give some sort of justice or fair results to the parties. Then what is happening there? Equity performs balancing act in between rigid one, that is the common law, and equitable principle, that is something fair. Equity permits the achievement of fair, just results in situation in which literal application of statute or common law might otherwise lead to the unfairness or injustice. Unfairness or injustice. Then if you don't deviate from the letters of the law, it may cause injustice or unfairness. Then what we should do is we must deviate. Just you can't deviate, then what you should do is allow the equity to do the justice. Therefore, equity permits the achievement of fair and just results in situations where literal application of law would not do that. Therefore, in this way, court can focus on reaching the best result in the circumstances, even where the literal application of statute or common law might seem to require difficult results. Then we will move to the next slide here. Equity operates on the conscience of the owner of the legal interest. In the case of trust, the conscience of the legal owner requires him to carry out the purpose for which the property was vested in him. One of the main principle equitable doctrine is that equity acts in personam. Equity acts in personam, one of the maxims that we will study later. But here, equity acts in personam on the conscience of the defendant, which means the main focus of the court of equity or court of chancery is to consider whether or not the individual defendant acted in good conscience. As we have discussed earlier also, the main idea here to identify the conscience of the defendant, whether he has done something in good faith or bad faith. If he has done something in good faith or good conscience, then he should not be liable. That is equitable principle. Equity acts in personam. Personam in the sense act in person, that's a Latin word, personam. Therefore, equity acts in personam. Personam in the sense act in person. Person in the sense we must see the conscience of such person, whether he has acted in good conscience or in bad conscience. That's why we simply nowadays we can say in Roman Dastro, or even nowadays we can say mana fide intention, bona fide intention. If he has acted with the bona fide intention, then he is liable, bad faith. Or if he has done something with a good faith, that is bona fide intention, then we must accept it. That we will see when we study the law of trust, provisions of the law of trust, especially provisions of the trust ordinance in the law of trust. Then here, in the case of trust, the consent of the legal owner requires him to carry out the purpose for which the property vested in him. Now, in the law of trust, there are three different actors: author of the trust, trustee, and beneficiaries. Author of the trust, who is the person who creates the trust. Trustee, the person on whom the confidence reposed. What confidence there? To do something, carry out some purposes for which the property transferred to trustee. Then author of the trust transferred the property to trustee. Then the trustee must keep the property or hold the property for the benefit of beneficiaries. Once the property transferred to trustee, trustee is the legal owner, even in equity as well as in common law. Then he can dispose, but he can't do that because of the equitable principles. The basis of the trust is concerned with regulating the conscience of a person where common law might otherwise allow that person to act unconscionably, but in accordance with the letter of law. That's the thing we spoken such a long time here. The ultimate purpose, when you go to the provisions of the law or the common law will say simply, author of the trust transfer the property to trustee. That's the end. That's the matter is over, because property now, the whole property transferred to B. That's the trustee here. Trustee is the legal owner. He can dispose. But equitable principle does not allow that, because it is a trust. Property transferred, the author of the trust transferred the property to trustee, not he, the author of the trust never ever transferred the beneficial interest to the trustee. The beneficial interest should go to the beneficiaries. Then the trustee, even though he is the legal owner of the property, he can't dispose such property. He must hold the property for the benefit of beneficiaries. That's why when you apply the common law will say, okay, very well, the trustee has the full power, he is the legal owner, he can dispose. But that cannot be done. That's why equitable principles playing a role there. Establishing a meaning for the term consent will be a difficult one. As we have seen in our criminal law also, we would have seen all the cases, in all the offences, we must establish the intention of the person who has committed the act or offence. Now, first of all, that's a basic thing in every offences. the intention part should be established, except in the strict liability. Like here also, the conscience of the owner of the legal interest. We must establish the bad conscience or the good conscience of the owner of the property. When the property transferred to trustee, trustee is the owner of the property, then the trustee must carry out the purpose for which the property was vested. What's the purpose for which the property transferred to trustee? The purpose is to give some beneficial interest to the beneficiaries. That's the ultimate purpose. Then it should be done. Even though the establishing a meaning for the term conscience will be difficult, some extent that should be done. The genesis of the term conscience in the early statements of the English jurist that courts of equity were courts of conscience. Earlier days, the English jurist said that when you say court of chancery, court of equity, whatever it is, that is courts of consciences. Because, and further, more significantly, the Lord Chancellor was keeper of monarch's conscience. The post of Lord Chancellor was referred to as a position of Lord Keeper. The rules of equity are historically taken to be an application of the monarch's personal power to give some sort of justice and to ensure that good conscience was enforced in that way. Then the ultimate purpose here, the court of equity or court of chancery, either way you can say, the chancery court always identify the conscience of the defendant who has committed or who has done some act. One thing. Second thing we have seen, the Lord Chancellor, earlier days from 13th century to 17th century, chancellors were priests or bishops. Then they have given their religious values also into their conscience. Then they used their own conscience also considered. In addition to that, now here we say that Lord Chancellor was the keeper of monarch's conscience. And also the post of Lord Chancellor was referred to as a position of Lord Keepers. The rules of equity are historically taken to be application of the monarch's personal power to give some sort of justice and to ensure good conscience were enforced in that way. Ultimate idea is to give some sort of relief, reasonable relief to the parties. For that purpose, we must identify the good conscience. If you identify the good conscience, then you can come to the reasonable relief to the parties. As I told you, the Lords Chancellor were bishops. Therefore, the conscience with which they were concerned were more religious conscience than the legal conscience until the beginning of 17th century. It means from 13th century to 17th century, the chancellor of the court were priests or bishops. when they give, when they identify, when they give the relief to the dispute, they use their own conscience. When they use their own conscience, it influenced by religious principles. That's why here we say that they were concerned, Lord Chancellors were bishops, and therefore conscience with which they were concerned was more religious conscience than the legal conscience until beginning of 17th century. The conscience which concerns equity is secular idea of conscience. Now after 17th century, the chancellors were appointed to the chancellery court from various people. Reasonable man, reasonable people there. Then they have used their own conscience in addition to that legal conscience. Therefore, the religious principles, whatever they applied, or religious conscience, what they applied during the period from 13th century to 17th century, it carried lot to identify the conscience of the defendant, by which we can create, by which the court created the equitable principles, which is very flexible, and the ultimate aim of the equitable principles is to give fair results to the parties, or we can say to do justice to the parties. After appointment of general people as chancellor, it was further developed and created created certain tools to identify the good consensus. Because of that, the equitable principles evolved from centuries to centuries. Now in this whole lectures what we have studied, first of all we have defined what is equity. When we see or when we study the equity, we have seen that the equity is associated with the notions of fairness, morality, justice, or in addition to that we can say moral values. It's a connection, but it is not the law, it is not the part of law, it's a branch of law. If the person aggrieved by the decision of the common law courts made an application to the chancellery court or court of chancellery to get some sort of relief, when the chancellery court hear the matter, they applied the equitable principles. The equitable principle in certain sense, it evolved from the conscience of the defendant, conscience of the monarchs, conscience of chancellor. That's the way it formulated. In addition to that, finally, we have seen that what's the connection of the law of trust and equity. Simply we can say equity is the base to the law of trust. The trust ordinance that we have now incorporated the equitable principles in every section thereof. When we study the law of trust, we must know what is equity. What is the role of the equity under English system or English system of law? And also we have seen the most significant equitable doctrine is law of trust. that is trust. Further, we have seen whatever said, all the trust, the law of trust, was born out of the equities focus. Because when you apply the common law, as I told you, you can't say that even the property transferred to somebody else, the beneficial interest should go to third party. That arrangement cannot be done under common law. That is something born from equitable principles. Now, the equitable principles, most of the equitable principles accommodated into the common law. When you study the equity, then only you can understand how much the equitable principles accommodated into the law of trust, especially in Sri Lanka, simply we can say in the trust ordinance. That may be very helpful to understand the provisions of the trust ordinance. That is the end of these lectures. We will continue the equity in other lectures. Thank you very much.